This is Barry Zalma on insurance. I'm an attorney who has retired from the practice of law and now spend my time as an insurance claims consultant and expert witness, an author and producer of these videos. Today I'd like to talk about the elements of the tort of fraud. To prove civil fraud, it is the obligation of an insurer to present admissible evidence that establishes the requirement of the common law that generally identifies 9 elements needed to establish fraud. 1. A representation of fact. 2. Its falsity. 3. Its materiality. 4. The representer's knowledge of its falsity or ignorance of the truth. 5. The representator's intent that it should be acted upon by the person in the manner reasonably contemplated. 6. The injured party's ignorance of its falsity. 7. The injured party's reliance on its truth. 8. The injured party's right to rely thereon. And 9. The injured party's consequent and proximate injury. The indicators of fraud that could lead to a conclusion that fraud is being attempted with regard to an insurance claim include: 1. Losses claimed a few days, weeks, or months after policy inception. 2. Losses claimed after recent increases in coverage limits. 3. Recent purchase of scheduled property or jewelry floater endorsements. 4. Purchase of additional scheduled jewelry endorsements spread over a few weeks or months prior to the loss. 5. Contact with an agent or broker indicates the insured asked many hypothetical coverage questions prior to purchase of the policy, such as an insured who demands a copy of the policy wording before agreeing to insure. 6. Black cloud loss history. The insured has many prior losses. 7. The insured has in-depth knowledge of policy limitations and claims procedures. 8. Losses involving theft of large, bulky items, such as a giant flat-screen television attached to furniture, roll-around tool chests and their contents, and/or entire contents of a residence. 9. Any larger dollar amount loss, especially on a tenant's or renter's policy. 10. All or many high-value items claimed were recently purchased. 11. The perfect claim. The insured provides receipts for all or many of the items claimed. The insured may also provide photos of which he has duplicates or which are saved in JPEG format to a memory stick provided to the claims person. 12. The insured refuses to provide answers to routine questions related to loss facts. 13. The insured cannot remember where he acquired what he described as special or unique items. He cannot provide detailed descriptions of what he claims is a unique item. And many more red flags. Insureds who are intent on pursuing fraudulent claims employ many devices, schemes, and artifices that operate to defraud insurance carriers out of billions of dollars in loss settlements. In an attempt to collect large loss payments, insureds may make untrue statements regarding material facts, conceal the true facts, and submit phony documentation. Values claimed are grossly inflated. Deliberate statements are made concerning nonexistent property, and deception and inconsistencies abound in the fraudulent claim. Successful handling, investigation, and defense against such fraudulent and often criminal activity requires a complete understanding of the various elements of property insurance fraud, as well as effective investigative approaches. For example, the use of bogus receipts is an integral part of many fraudulent claims and provides an excellent opportunity to expose the suspected claim. There are 4 general types of fraudulent claim activity which dishonest individuals, insureds, and third-party claimants engage in to recover policy proceeds fraudulently. Those activities involve 1. Obtaining insurance under false pretenses by misrepresenting or concealing material facts in an application for insurance. 2. Creating a loss. 3. Staging a loss. 4. Exaggerating the amount of loss. And 5. Misrepresenting the cause of loss. Some claims involve the creation and exaggeration of the loss, and some involve all 4 types of fraudulent claim activity. Fraud in the inception requires people who intend to defraud a first-party insurer and will seek to obtain the broadest and least expensive insurance available. To obtain that insurance, the prospective insured, the applicant, will fill out an application for insurance that paints the prospective insured as an almost perfect risk, so that his application will result in the issuance of a policy. Since a fraud perpetrator is a criminal who understands crime but may not understand insurance, he or she will have no problem misrepresenting material facts or concealing material facts from the insurer, like his or her prior loss history, prior cancellations, or non-renewal of earlier policies, or the condition or value of the real and personal property. One of the most common types of loss is that which is created and is called arson for profit, where the dishonest insured or someone at his or her request intentionally sets fire to a structure and its contents. Dishonest individuals can also create losses by explosion, water, vandalism, and staged burglaries and thefts. This type of claim activity may also involve the exaggeration of the amount of loss, in that property claimed to have been destroyed may not have been on the premises at the time of loss, or never existed, or the value of personal property or equipment is overstated with intent to increase the amount of recovery. Arson for profit is an evil version of insurance fraud, since people can be injured or killed in an arson fire. In a case where a person who, but for the heroic efforts of firefighters, escaped a painful death in an arson fire set by the defendant, still resulted in an appeal from the person convicted of the crimes of arson and insurance fraud. The appeal was shut down with alacrity by the appellate division of the New York Supreme, its trial court. In the People of the State of New York versus Zabida Permaul, a 2019 decision, the defendant and her husband purchased a building in the city of Schenectady with restaurant space on the first floor and 2 apartments on the second. By 2015, the defendant was estranged from her husband and managing the restaurant, living in one of the apartments and renting out the other. In the late morning of February 22, 2015, a fire started on the stairs leading up from the basement. Defendant had just left the building, but her tenant called 911 after smelling and seeing smoke. Due to the heavy smoke in the stairwell, the tenant did not escape the building and waited for assistance. Firefighters forced their way into the locked building, guided the tenant outside, and extinguished the blaze. Defendant then made claims against her business owner and renter's insurance policy issued by separate carriers, in which she misrepresented that there were no liens against the property. The subsequent investigation revealed that defendant was in financial distress at the time of the fire, and that kerosene, diesel, or a similar accelerant was present on the basement steps where the fire had started. Those and other facts led investigators to believe that the defendant had set the fire herself in order to pursue fraudulent insurance claims, and she was charged in an indictment with various offenses. Following a jury trial, defendant was convicted of arson in the first degree and 2 counts of insurance fraud in the second degree. County court imposed a sentence of 25 years to life in prison upon the arson conviction and a lesser concurrent sentence on each insurance fraud conviction. The proof adduced at trial established the fire was not natural nor accidental in origin and caused damage to the building, as well as that the defendant knew or could reasonably suspect the tenant was present, leaving the questions of whether defendant intentionally set the fire and did so for financial gain. Defendant was in dire financial straits by the time of the fire. She stopped repaying numerous loans, but continued to pay her insurance premiums and made such a payment for her business owner's policy a few days before the fire. About an hour before the fire broke out, defendant was alone in the restaurant and deactivated the building's security cameras. The tenant testified as to what followed, stating that she overheard defendant having a telephone conversation about numbers and soon smelled something similar to gasoline. The tenant then detected smoke in her apartment, which an investigator testified would have occurred 2 or 3 minutes after the fire had started, given the accelerant used and the layout of the building. There was no response from defendant's apartment when the tenant tried to raise the alarm, the reasons for which became clear when the tenant looked out the window and saw defendant and her son leaving the scene in a car. The tenant also spoke to the defendant later that day, and defendant stated she was carrying her passport and her valuables when she left the building that morning. The jury credited the proof of defendant's guilt, despite her testimony and the lack of physical evidence tying her to the fire, and deferring to that assessment, the jury found the conviction for arson in the first degree to be supported by the weight of the evidence. It is the utmost variation on chutzpah, Yiddish for unmitigated gall, to try to claim your lawyer was inadequate because you were convicted, even though he presented a defense with a yeoman's effort that failed because of the existence of unimpeachable evidence. Her lawyer could not overcome the fact that the defendant was seen to leave the building just as the fire broke out, that she took her passport and her son with her, and that the fire was started by the use of an accelerant poured down the basement stairs and finally almost resulted in the death of the tenant. She should and will spend most of the 25 years assessed against her in state prison. Other types of intentional insurance fraud include staged losses, exaggeration of the amount of loss, misrepresentation of the cause of loss, overvaluation, and other variations on intentional fraud. When the claims person finds a potential for fraud, whether as a staged accident, a staged theft, or an arson for profit, the investigation should include, at the very least, 1, a detailed statement from the insured covering a complete description of the property, including its features, where it was purchased, how it was purchased, the date of purchase, and the amount paid. 2, the claims person must determine if the insured has a receipt or other proof of purchase, such as canceled checks. The claims person, 3, should determine if the insured has any photographs or digital photographs of the property claimed lost. 4, the claims person should determine if there are any parts of the property available, not stolen, such as remote control units, owner's manuals, or the box the item came in. The adjuster should document their existence with photos or obtain the items left behind. 5, does the retailer have a record of the purchase, especially of major items that are less than a year old? 6, the adjuster should document the investigative actions with statements, either recorded or signed. 7, the adjuster should determine through retailers, suppliers, or catalogs the proper replacement value of the items claimed. 8, the adjuster must apply appropriate depreciation in accordance with published schedules. 9, even if the insured has no receipt, the adjuster should obtain his or her best recollection of the place where the item was purchased. And 10, if the insured claims it was purchased with a credit card, the adjuster should always obtain a copy of the card or the numbers of the card and access to the computerized schedule of items purchased with that card from the card issuer. This video was adapted from my book, Property Investigation Checklists, 13th edition, which is available from Thomson Reuters and can be found on my insurance claims library on my website, zelma.com. If you found this video to be interesting or useful to you and or your colleagues, please pass it on. It's free. And please subscribe to my YouTube channel, my Rumble channel, and my blog so that you can be advised of future videos and future blog postings. Thank you for your attention.